Welcome everyone to our final class of the semester. I'm really excited to introduce my friend and colleague, Matt Karlyn, who's going to talk about licensing. Please remember, if you have questions, to use the chat function and we'll make sure we answer them. It's been a great pleasure having all of you attend the class. We're going to send out a survey. So please respond to the survey and let us know what you think, how we can improve the class for next year. So with that, Matt, take it from here.
Terrific. Thanks so much, Mike. I'm going to go ahead and share my screen. Give me a second there. Hopefully you can all see that now. I'm super excited to be here. Thanks, Mike and team, MoFo team, for inviting me. Happy to be the last in what I've heard is a really phenomenal series of presentations and classes. Really excited that you're all here and want to learn a little bit about what we do in the commercial space with respect to patent law and licensing, and how we take all of the incredible things that you are all inventing and we actually put it into production and practice and ultimately make products that get sold in the marketplace and hopefully someday around the world. And so that's what we do. So this is session 10. We're going to talk about licensing topics. I'm Matt Karlyn. I'm a partner here in Morrison Foerster's Boston office. I am part of our technology transactions group and our life science transactions and licensing practice. And really, really excited to be here today. So let me advance the slides here. I found this quote. I was kind of going through my presentation and updating it a little bit from past presentations and noodling with a few things. And I found this quote that I thought was super relevant and put a smile on my face. The rewards for biotechnology are tremendous, as of course you all know. To solve disease, eliminate poverty, age gracefully. It sounds so much cooler than Facebook. And of course, that was George Church, who I'm sure many of you are familiar with, particularly here in the Boston community, but also around the world. I just thought that was really, really an interesting perspective. What you are all doing in labs and in your positions and what you might be doing someday in your jobs is you're using all of your incredible tools that you have to solve so many of the world's problems. And one of the things that we in the commercial space get to do is we get to take those things and we get to use them in such a way that they actually become products downstream. And we're going to talk a little bit today about how that happens and about some of the vehicles that you can use to make that happen. I get super excited about it. It's what I do for a living and what my team here at MoFo does. We love working side by side with all of you to make that happen. So when we think about life sciences at MoFo, I'm sure you might have heard this in past presentations. I'll just repeat it a little bit here. When we think about life sciences at MoFo, we think about 4 core areas, although there are several others, several areas in the periphery, but we think about 4 core areas. You learned a lot, I think, in past presentations about the intellectual property area, certainly about patents, about know-how, about trade secrets, about all of the different types of intellectual property that are part of the life sciences ecosystem. Of course, there's a corporate element to it, forming companies to essentially take all of the things that you're inventing and ultimately commercialize them as part of a corporate entity. Of course, there are regulatory issues when we talk about drugs. We talk about vaccines, we talk about therapeutics, we talk about medical devices, we talk about all of those things. Of course, there's an enormous regulatory component to that, and I'm sure you've learned quite a bit about that. And then the fourth part of it is the licensing, or is the commercial element. How do we take what you've developed and partner with other companies or do it on our own, or how do we take all of that and actually get something into the marketplace that can benefit a consumer? And that's what we're going to talk a little bit about today, or a lot of it about today over the course of the next hour. So what's the importance of what we do here in the commercial space? Well, we work with companies, we partner to bring products to market. This has always been a critical part to the success of large and small companies. Partnered assets. When we talk about a partnered asset, we talk about taking the intellectual property of a company, partnering or collaborating is another term you might hear, with another company to ultimately contribute both parties' intellectual property, resources, materials, people in order to develop a product. So partnered assets generally make up more than 50% of the research and development pipeline in most big pharmaceutical companies. So when you think about the big pharmaceutical companies out there, the Johnson & Johnsons, the Merck, the Novartises of the world, more than 50% of their R&D pipeline is a result of partnered assets, meaning that they're partnering with other companies, usually smaller companies, in order to contribute to their research and development or the research and development in their companies. They need these collaborations in order to complete development of their products and ultimately commercialize those products to generate, revenue. That's a huge, huge part of what they do. And so all of what you are all maybe in smaller startup emerging companies, what you're contributing plays a huge role in the life sciences ecosystem, in the development of drugs, in the development of medical devices, in the development of all of the elements that we ultimately require in order to have a really robust and complete life sciences ecosystem. Understand that due to the high risk and high cost of research and development, the long timelines to success, as many of you already know, it takes a long time in order to bring a drug to the market. And the often complex regulatory and intellectual property framework, it can be a web, it can be a maze to get through some of the intellectual property and regulatory hurdles. These deals cover certain unique areas, and we're going to talk a lot about that today. I encourage you all to use as Mike said, to use the chat to ask questions, and we'll try to answer those along the way. But please, if you have a question, please don't hesitate. So when we talk about deals in this space, what are we really talking about? Well, there's tons of different types of collaborative agreements and transactions that you might be familiar with, or you might become familiar with along your journey. Today, we're going to talk a bit about license agreements. Licensing agreements are a type of collaboration agreement. You might hear about things like distribution agreements or co-development agreements. Certainly, you might someday set up a joint venture in order to bring a particular product to market or co-develop a particular product that you ultimately will bring to the market. Ultimately, we're talking about coming together in some collaboration between two or more parties to varying degrees in new research, development, manufacturing, commercialization of new products. That's ultimately what we're talking about, the coming together of companies. It can be two, it can be more than two, in order to ultimately contribute something to the commercialization of a product. Essentially, these agreements contain a very simple grant of rights. They don't need to be complicated. Many of them are very complicated. They don't need to be complicated. And we talk a lot about the collaboration in a bunch of different material respects. And we're going to talk a little bit about what that means. So let's talk a little bit about collaboration and about these types of deals. So a little bit of an overview here. What do we require when we enter into a collaborative arrangement with another company? Certainly we require capital, money, and we require time. A biotech product can take up to $2 billion to develop. Many of them don't. But it can take an enormous amount of money to develop a product. And ultimately, from start to finish, we might be talking about a decade or more from the early stages of research and development, ultimately to commercialization. So when we put these transactions together, we understand that the collaborative parties, all of the parties that are entering into this relationship, are going to be economically impacted, are going to be taking certain economic risk, and are going to be or have to be in it for some certain period of time, at least, typically a decade or more. The unfortunate reality and the risk associated with these transactions is that about 10 to 20% of products entering clinical trials will ultimately be approved and commercialized. So when you think about all of the risks associated with what you're getting into, the risks are significant. There's a lot of time that's needed. There's a lot of money that's needed. And even if you invest all of that time and money, the statistics still kind of work against you. And so when we draft these agreements, we have all of that in mind, and we draft in order to hopefully protect the parties against some of those downstream risks. Certainly there's new regulatory issues, and the reality with regulatory issues in the United States, but also around the world, is that they change. They change with the new administrations. They change with varying degrees of research associated with safety concerns. There's a lot of different elements that drive fluctuation and uncertainty with respect to regulated markets. Where we practice, the area we practice in is a heavily regulated market. And we have to always be a little bit forward thinking at the edge of our seats in order to anticipate what changes might ultimately impact what we're putting together as part of a collaboration downstream. In terms of the timing to get these deals done, give yourself some time. Some of them can take a few weeks, many take months or more. Some of the bigger collaborative deals that we do can take 6 or more months. And so give yourself some time. One of the things we always say when we put together these types of agreements is be in a hurry to finish, not to start. Kind of take your time at the beginning, understand the risks associated with these types of transactions, work to figure out how we're going to address those risks in the contractual documents. And then once you get all of that figured out, then you can start to pick up steam and kind of drive towards the end goal, which is getting a signed agreement. The reality is that so many of these deals are unique. Many of them are novel. Many of them, are deals we put together based on the facts that we have. And it's very difficult to turn to a form agreement. That's not true for everything we do. But it is true for a lot of the collaborative and the licensing deals that we do. There are starting points, and certainly we help our clients find the right starting points in order to make sure that they've covered off on all of the critical terms. But ultimately, the facts will really dictate which turns your particular document take. And then, my goal with respect to all of these deals is that they've really got to be win-win. There is such a thing as getting too good of a deal. Oftentimes deals that are too good don't end up working out because one party ultimately will feel slighted or will feel like they're not getting the benefit. They're investing more than the other party is investing, but they're not getting as much out of the collaboration as the other party is getting. If you don't ultimately arrive where both parties believe that they've won, then you really run the risk of some downstream issue impacting the collaboration. And when I say collaboration, I really mean that we have to collaborate. We have to come together in order to drive something forward. And so keeping that in mind, when you think about terms of these deals, think about what's a win for you. Of course, that's important, but what would also be perceived as value to the other party. And that's true in a license agreement. And that's true in any of the collaborative types of agreements that we do. So today, we're going to talk a bit about a whole bunch of different elements of these types of deals. I've just given a little bit of an overview, but we'll dive a little bit more into that. We're going to talk about the nature of a license and then a bunch of different elements of license agreements. I've included here a little bit about university licensing, which I believe a lot of you are interested in, and certainly we're happy to talk about that. We do quite a few university licenses annually here in MoFo's group. And ultimately, we're going to hopefully leave you with a whole bunch of really relevant information when you start to think about doing deals, licensing, collaborations, joint development deals, these types of agreements. You have some of the tools in your toolkit to start thinking about what terms would be appropriate in your transactions. So let's kind of start at the beginning. I know this is a little bit basic for a lot of you, but really you have to start at the beginning when we do these transactions with really understanding what is a license. So at the very basic level, a license is just simply a waiver. It's a waiver of a right to sue a party for conduct which, absent the license, would be actionable. meaning if you utilize the intellectual property that was being licensed, absent a license, then the party that owns the intellectual property would have a claim against you, likely a claim of infringement of their intellectual property rights in the intellectual property that you're using. The license waives that right. A license agreement is a contract. It's a contract between a licensor, the party that owns the intellectual property, or has the rights to license the intellectual property, and a licensee, the party that wants to use the intellectual property, that allows the licensee to make some specified use of the licensor's property. The licensor's property would not otherwise be available to be used by the licensee, or if used, then that use would be actionable by the licensor. It's a grant of rights. It's just simply a grant of rights. It is not the transfer of physical technology or materials or information. That all separately has to be provided for in the license agreement. The license itself is simply the right to do something with the intellectual property that's owned by another party. Super simple. So when we talk about patent licensing, we're talking about exactly what we were just describing. A patent license is an agreement between a patent owner and a licensee to transfer interest in a patent license to the licensee. The licensee can then benefit from and ultimately enforce the IP rights in the patent. And that would all be described in the actual patent license agreement. I've included two terms here which are of particular interest and things that you should really figure out ahead of time, whether or not the license in the license agreement is exclusive or non-exclusive. If it's exclusive, the licensor is fully transferring their interest in the patent to the licensee, including with respect to the licensor. If it's non-exclusive, then the licensee is not gaining exclusive rights, and the licensor would retain for itself the right to license that intellectual property to another licensee. And there's lots of different bells and whistles that go along with exclusive licenses versus non-exclusive licenses. Exclusive licenses tend to be more expensive than non-exclusive licenses. But there's reasons why you would want an exclusive license versus a non-exclusive license. One isn't better than the other, but they're different, and it all depends on the facts in your circumstances. So, think about whether or not it makes sense to have an exclusive license in certain scenarios, or whether or not it makes sense to have a non-exclusive license in certain scenarios. There's lots of advantages to patent licensing. Not all inventors want to commercialize products from their inventions. Well, you all are inventing really incredible things, but you might not want to take that invention to the next level, but you nonetheless might want to be economically advantaged by your investment of time, money, resources into creating that invention. Well, what does licensing do? It gives your IP, licensing your IP gives you an upstream profit from the rights to your invention. So instead of your invention just simply sitting on a shelf with nobody doing anything with it, you can license it and get some economic upside associated with your invention, as opposed to doing nothing with it, or feeling like you have to invest all sorts of time and resources in the invention in order for there to be some economic value to it. Licensing is a significant transfer of risk. Taking the commercialization process under your wing, like we said, can be extraordinarily expensive, can require a ton of human capital, can take a really, really long time. But patent licensing to the right licensor provides a vehicle to essentially transfer that risk to another party and potentially provide you with some positive economic impact. It could give you access to markets that you would otherwise not have access to. Scaling products takes an enormous amount of time. Lots of companies don't have the capital infrastructure in order to scale products on a significant basis. But partnering with another company and licensing your IP to another company might give you that ability that you otherwise wouldn't have. And then you could eliminate patent infringement. So consider a license to your invention instead of the cost of enforcing your intellectual property against infringers. Enforcing intellectual property rights against infringers is, again, timely. It takes a lot of time. It costs a lot of money. It can be extraordinarily lengthy to get a result that's positive to the company. But by licensing your intellectual property, you can essentially avoid the enforcement construct and also gain economic advantage. So there's lots of different advantages to patent licensing, and something that we work with companies all the time to put in place a strategy with respect to when's the right time to start licensing your intellectual property, to whom should you be licensing your intellectual property. There's good partners and there's bad partners. And what are the requirements that you would impose on that collaborator associated with the use of your intellectual property. And we're going to talk a bit about that today. We talked a little bit about this already. Each licensing agreement is unique. That's probably true most of the time. Certainly they follow a certain pattern, but you have to really consider your business objectives with respect to the license arrangement before you just simply, do a Google search and look for a license agreement that you kind of think fits. Really, I mean, the two key points I would leave you with are, think about your business objectives before you even read an agreement. Write down in plain English, what do you want to achieve? Think about that as part of like the cornerstone of your strategy. What do we, XYZ company, ultimately want to achieve? Let's think about that first. And then let's sit back and think about, okay, what are the risks associated with what we're about to do? And then as a final step at an initial stage, I would want to start thinking about how can we alleviate the impact that those risks might have on the business? Are there ways that we can do that? Either through contractual language or through finding the right partner or through various protective measures that we can take. I would do all of that before I start searching for a license form or a joint development agreement form or something like that. Because if you don't have all of those facts and you don't have that really fully fleshed out, you're not going to be reading agreements and finding the right form ever, because you just simply aren't aligned, and those forms won't be aligned with what the business is trying to achieve and what risks the business is trying to avoid. So each license agreement, is different. Understand that going in, and really do the homework first, as opposed to just simply trying to find a form that fits your needs. So getting started, the whole concept of being in a hurry to start, being in a hurry to finish, rather, not to start, really starts at the very beginning. Figuring out what we're trying to accomplish, figuring out what we want to get out of the relationship that we're thinking about entering into, thinking about what rules are going to govern the collaborative effort between or among the parties to the collaboration, deciding who we're going to partner with, and doing some diligence, asking the right questions, asking folks like your lawyers who are familiar with this, your business partners, your advisors, your scientific advisory board, whoever it is, to contribute to what's the strategy associated with this collaboration, this license, whatever this is. And then, like we said, identifying the objectives of the collaboration. Keep in mind, always keep in mind, I mean, two kind of critical factors. One we already talked about, which is win-win-win. How can everybody get what they want out of this effort? And how do we structure it to make sure that that happens? Why? Because these relationships are often long-term relationships. We might be in this collaboration for a while. It's kind of like a marriage. So we're going to date for a long time before we sign that paper. And then ultimately we're going to get married, and we're going to stay married for a while. And we don't want anything to disrupt that. Now, there will be bumps along the road, and we're going to draft in the transactional document how we solve for those bumps. But we want to avoid those bumps as much as we can. So keep that in mind when you do these deals. So again, starting a little bit from the beginning, what is licensed under a license agreement? Well, intellectual property. And you've talked a lot about that, I think, over the course of the past 9 sessions. I'm not going to get into detail here. You've learned all about patents and copyrights, trade secrets and trademarks, know-how, and all of the other technology and things that go into and comprise intellectual property that's ultimately licensed in a license agreement. What are the types of licenses that you're going to encounter? We talked a little bit about the non-exclusive and exclusive and the differences between those. There might be a license agreement for a particular product. Certainly you can license copyrights and trademarks and trade secrets. Oftentimes trade secrets and know-how and technology and all of that gets wrapped into a patent license agreement. And certainly you're going to encounter that. And we definitely talked about patent licenses and the licensing of intellectual property and patents and how that all works. So at the very beginning of a license agreement, usually it's section 1, maybe after the definitions. If the definitions are section 1, it might be section 2, but there's usually very easy to identify right up front is the license grant itself. Arguably, probably one of, if not the most important clause in a license agreement. What's the purpose of the grant? We're in the grant going to describe the rights that must be conveyed in order to achieve the desired purpose. I beg you to read the license grant. I can't tell you how many times we enter into disputes because the parties did not fully flesh out the rights to be granted to the intellectual property. Either the licensee did not do the diligence that was required, did not appropriately read the license, did not scope it out appropriately, and lo and behold, the licensee does not have all the rights that the licensee needs in order to do what they need to do and achieve the stated purpose of the collaboration. It happens a lot, and the best way to avoid it is, again, take a step back, just read that clause, and make sure that that clause aligns with the stated business objectives of the company. So you're going to see things like the licensee has the right to do things like research or manufacture, to sell or have sold, to promote, to commercialize, to make, to have made products that are directed to or otherwise utilize the intellectual property that's licensed under the license agreement. You want to make sure that you have all of the words you need and that you understand what those words mean and that those words align with the business objectives of the company. And then you want to ask a whole bunch of questions. So on top of the license grant itself, will we need to sublicense the rights that were granted? If you need that right, then you need to say that you need that right, and the licensor needs to convey that right to you in the license agreement. So ask the question, understand what the answer is, and then make sure that the license agreement aligns with the answer. And then what restrictions are contemplated? Is the license limited to a specific field of use? Often it is, not always. But often it is. Have you described the field of use to contemplate precisely what is required or what the business needs in order to achieve its business objectives? Spend a lot of time on that. Is the field of use broad enough to align with the business objectives of the company and what the company ultimately contemplates with respect to commercializing the licensed product under the license agreement? Are there geographic limitations? Not always, but often. And so think about whether or not a worldwide license is required in order to achieve the business objectives, or whether it's only directed to specific countries. So lots of different restrictions that you're going to want to pay attention to. Now, again, we're talking about exclusive and non-exclusive. And like I said, one isn't better than the other. They're different. And there's lots of times when a non-exclusive license is precisely what you want and what the licensor is willing to grant and all you need. There's other times when an exclusive license is what you require. So one's not better than the other. They're just relevant to different facts. And figuring out whether you need an exclusive license or a non-exclusive license would be critical to the process. And then what are you licensing? Are you licensing just simply the rights under a particular patent? Or is there additional intellectual property that you need in order to ultimately make the commercial product? So for example, do you need the licensor to convey to you certain know-how? Is there anything else that you might need in order to ultimately fulfill the purpose of the license agreement and ultimately bring a licensed product to market. So lots of different things here to think about. A little bit of a checklist. I think at the back of the presentation, I actually include a checklist, but just things to think about and things to kind of slow down, really make sure that the license grant itself aligns with the business objectives, I think, before you do anything else. Because this is one of the areas where these agreements go sideways. And trying to avoid that and drafting your contractual documents in order to avoid that really can be helpful, so that when there are bumps in the road, the parties can quickly and efficiently figure them out, so it doesn't completely destroy or otherwise negatively impact the collaboration and the relationship. So here I've just included some examples that you can certainly think about in your own time. I won't spend too much time here, but again, we talked about all of these on the previous slide, and some examples that you can kind of think about whether or not these make sense for your particular deals. Again, some more examples here. There is a difference between a sole license and an exclusive license. The exclusivity would be exclusive. When we say exclusive license, we mean exclusive as to any other licensee, as well as to the licensor itself. But in a sole license, if you ever see that word, typically what we mean by a sole license is that it would be exclusive as to both the licensor as well as the licensee. And so the licensor in that regard reserves certain rights associated with the intellectual property that's being licensed that the licensor wouldn't otherwise reserve for itself in an exclusive license. We talked about the types of exclusivity. We're going to talk about diligence later on, so I'll leave that for later. And we're going to talk about licensee concerns later on as well, so I'll leave that for later too. I think Mike's appearance might indicate that there's a question.
Got a couple of questions.
Great.
First, can you explain the difference between a trade secret license in terms of the risk of the secret loss versus patent and trade secret combination licenses? And the question is, wouldn't you always want a patent and trade secret license together, or would you want them?
No, not always. I think perhaps typically we would include a broad definition of other intellectual property that might include trade secret. It might include know-how. And often you would see those coupled together. So the license itself would be to the patent or patents, as well as to, a lot of time we define it as licensor technology, licensor innovations. And in that definition, we would include trade secrets and know-how and technology and developments and all sorts of other things that we might want to license from the licensor, because we require all of that in order to ultimately be part of our process in commercializing a licensed product. Not always. There are straight patent licenses where all we need is a license to the patent, and that's it. So the answer to your question, I believe, is I'm not sure I would go so far as to say most of the time, but I definitely would say the majority of the time you will see a patent license coupled with a license to technology, which would include some of the other intellectual property that you've identified.
Can you explain what the licensing structure would allow a company that's receiving a license for a trade secret to further develop the technology?
Say it one more time, Mike.
So I think what they're trying to understand is the structure that you might put together if you're getting a license and to a trade secret and you want to further develop the technology.
Okay, great. Yeah, absolutely. So you would want a license. So your license grant itself would have to extend to your ability to improve the licensed technology, and then you would absolutely have to go through the process of determining the allocation of intellectual property rights to those improvements. But to the extent that you're going to take whatever is being licensed, the licensed technology, the know-how, the trade secrets, whatever it is, and you're going to invest and contribute economically, you're going to contribute human capital, you're going to use lab space, you're going to use equipment in order to create something that is derived from what you're licensing under the license agreement. You need the right to do that. And then the big $24 million question is going to be, well, who owns the output of that? And the license agreement will parse through and determine and allocate the ownership rights to those improvements, to any data or any other output associated with making those improvements, and so on and so forth. But it absolutely can be done and is often done.
So another question is, if a partner company is involved in product distribution and sales, does that partner normally need a sublicense in order to do that?
The answer to that question is it depends. Often, yes, but it will depend on how your license grant is structured. So to the extent that there's have-made rights in your license grant, the answer might be no. But to the extent you are going to partner with a company in order to in some way contribute to the development, the research, the distribution, the answer is likely yes. And you're going to want to think about the likelihood of that happening. And that's where the sub-licensing rights really come into play. And oftentimes they're going to take that question just one step farther. You're going to see in the economic terms, I think I talk about it later in the presentation, hopefully we can get to it. But in the economic terms, there is a whole part of the economic structure that deals with sub-licensing. And to the extent that any revenue is derived by the licensee associated with sub-licensing, how does that economically impact the licensor? You need to figure all of that out. And licensors will be seeking a share of revenue received by the licensee associated with sub-licensing of the intellectual property rights under the license agreement. That was a huge mouthful. I apologize for that, but hopefully we'll get to that in the economic discussion.
That's great. All right, go ahead, Matt.
Okay. Let me just look at the time real quick. Gosh, Mike, I need like 2 or 3 hours, not just 1 hour. So let's skip ahead a little bit and think about issues in the license. If you are the licensor, and we talked earlier that you might be the licensor because oftentimes you are thinking about really innovative in creating innovative intellectual property that you might want to license in the future. If you're the licensor, here's a whole bunch of things. Use this as a checklist. I'm sure you can think of others as well that you want to be aware of when you read those license grants. We don't have time to go through all of these, but take a step back, think about all of these issues and several others that I'm sure you can come up with, and make sure that the license grant aligns with whatever your answers are to these concerns or questions and any others that you come up with. If you're the licensee, it's kind of the opposite. When you're the licensor, you might think that the license is too broad. If you're the licensee, you might come to the conclusion that the license is too narrow. There's lots of different things that you as the licensee are going to be concerned with. And so think about, here's all of our concerns. Here's all of the different areas of the license agreement where those concerns could be addressed, and here's how we want to address them. The licensor's perspective when it comes to the scope of licenses, they want to define the licensed IP very clearly. To be perfectly honest, the licensee should want that too. We want to define clearly what's being licensed. That's super helpful to all parties involved. They're going to want to keep the scopes narrow. They're going to want to clearly define whether the license, of course, is exclusive or non-exclusive, keeping in mind, of course, what we talked about earlier, that exclusive means exclusive, and that includes the licensor, unless that's provided otherwise. Okay, so the licensor is going to want to the extent that there's a reservation of rights that they require, they're going to want to clearly describe what that reservation of rights looks like with respect to the intellectual property that's being licensed. To the question that was asked earlier, they're going to want some control over sub-licensing. And so you might see language that says that, XYZ intellectual property, you have a license to use and to make and to have made, and it's sublicensable. And then you might see in parentheses or in some other way through multiple tiers of sublicensees. You might not see that, but you want to be mindful of the concept that to the extent that your sublicensee would ultimately require a sublicensee to perform whatever your initial sublicensee's requirements are, they're going to need that sublicense, that downstream sublicense. That's a second tier of sublicensing. And so the multiple tiers of sublicensees provides the ability of the licensee to accomplish that. Licensors might restrict that. And there's lots of reasons why they might do that, but keep that in mind when you read the sublicense language in your license agreements. If you're the licensee, you're going to want to broaden that scope up. That's a super simple way of saying, make it broad. You want broad rights to the intellectual property. You really want to anticipate all the uses and activities that you might require as a licensee and include them in the license grant. So broaden it up as much as is reasonable. Don't forget the win-win-win concept that we talked about earlier. Don't forget that you have to live with this for a long time, and we don't want anything to disrupt that. But you're going to want to broaden it up and really make sure that the grant itself and your ability to use the intellectual property aligns with the company's business objectives. A couple examples here. I'm going to skip these. You can read them in your own time. But just some examples. Please don't cut and paste these into your documents, because like we said, there's no one form fits all. It's all fact dependent, but I wanted you to have at your fingertips some language just to kind of see how what we've been talking about for the last half hour or so plays out in practice. So that was a pro licensor license grant. This is a pro licensee license grant. You can, in your own time, kind of see what the differences are. One's really narrow, one's really broad, one has more rights, one has fewer rights, so on and so forth. Another example included there. That, deep breath, that takes care of kind of the core elements of the license. That section 1 or section 2 of your license agreement or your collaboration, if that includes a license, which they often do. So that's a big chunk. And then everything behind that, so sections 3 through whatever it is, 10, 11, 12, everything behind that is how do we ultimately use, pay for, monitor, govern the use of what we've licensed. How do we get from the license to a product on a shelf, or a product that's prescribed, or a product that's approved, and ultimately makes money? So there are things like diligence obligations. You are going to see these. And what this means is, particularly in the exclusive license scenario, and we'll talk about why that is, but you're going to see a requirement that you, the licensee, actually do something with the intellectual property that's licensed. In an exclusive license, we want to encourage, we, the licensor, want to encourage the licensee's performance. We don't want you to take an exclusive license of our intellectual property and do nothing with it. And so diligence obligations impose an obligation on the licensee to actually do stuff in order to get a product to market, in order to maximize the economic benefit to the licensor. If a product never makes it to market, then the significant economic upside to the licensor will never be realized. There's other economic upside that might be realized, kind of interim milestone payments and whatnot, but the significant economic upside might not ultimately be realized. And then from the licensee's perspective, just be mindful that these tend to be extraordinarily burdensome, and you want to monitor that. And you want to make sure ultimately that you can meet the diligence obligations. We don't want to be in breach of our license agreements for failure to meet diligence obligations. So they're heavily negotiated. They're often mandated. So be on the lookout for these. But certainly they're negotiated, and certainly you can arrive at a workable solution for both the licensee and the licensor. Mike, you're back.
Yep, a couple more questions.
Sure.
When an exclusive licensee fails to continue development of technology as agreed upon, are there provisions like take back rights that can be included in the license agreement so that the licensor can then exclusively license the original IP to another party.
Yes, that's what we were just talking about. So that would all be wrapped up in the diligence obligations. So failure to meet those diligence obligations would give rise to either take back rights or a reservation of rights in the licensor. It would be a breach of the license agreement that the licensor could enforce. And then the licensor would have to make a determination with respect to what it ultimately would want to do. But the answer to the question is yes, and that's literally kind of wrapped up in what we were just talking about.
Why are royalties or lack thereof called out specifically in the license grant, but not other types of economic considerations?
Called out in the license grant, typically if you were getting that's a good question. We would typically see that if you were getting a royalty-free license, meaning there would be no downstream royalties payable to the licensor associated with the licensed product. We often also put in a royalty-bearing license. That's a great question. It might simply be a matter of practice. It might also simply be a matter of understanding that the license is being granted in order to create a commercial product, and a royalty would not be payable before there would be net sales on a commercial product. And so it's intricately tied to ultimately the license itself that is required in order to get a product to market. That would be my best answer.
So when you license from a university, say Harvard, MIT, University of California, places like that, are there any of these considerations different? Are there differences in licensing from universities?
There are not differences in licensing from universities in terms of the construct that we're talking about here. There are differences in your negotiating leverage. There are differences in the forms that you're going to use. There are, and we'll talk a little bit on the economics. There was a question in our last session about whether or not licensors take equity in companies. Universities do, and often do, and will. There's a huge trend, and has been for years, with respect to universities taking an equity position in licensees. But the construct itself is not dissimilar at all to what we're talking about here.
Okay, thanks.
Yep. So getting a little bit more into the weeds on the diligence question and what the respective rights of the parties are, these are the types of diligence that you're going to see. And to get to the question that Mike just asked, if you don't do these things, then there would be a reservation of rights in the licensor, and the licensor would have certain remedies associated with that. So keep that in mind when you as the licensee go to draft these. You want to make sure that the diligence really aligns with what you're capable of doing. So some compromise positions to think about, certainly agreeing to extensions. There's lots of things that can go wrong in the development of commercial therapeutics or drugs or vaccines or whatever you're developing. There's medical devices. There's lots of things that can go sideways that have nothing to do with the relationship between the licensee and the licensor. And so keep that in mind, and think about cure periods, and think about buffer times between an event that gives rise to a breach of the agreement and ultimately the licensor's ability to terminate the agreement. Subjecting them to commercially reasonable standards and understanding and agreeing to what's meant by those standards. And then using money as an indicator of diligence. This is something that's kind of gaining some traction, where if we invest certain amounts of money, capital, both money as well as human capital, in the development of a product, notwithstanding the fact that perhaps we haven't met a particular milestone with respect to the development effort, consider that being an indicator that we're in indication of our investment in getting a product to market, and thereby satisfying the diligence obligations in the agreement. Certainly something that we see quite a bit of. Some more examples for you to ponder in your own time. with respect to diligence, some language that you can parse through and see how this actually plays out in agreements. So here's the monetary consideration part of the presentation. This is really can be used as a checklist. These are the types of economic terms that you're going to see in license agreements. And this goes for university licensing as well as licensing between non-university partners. You're going to see upfront payments. It could be cash, it could be equity, it could be a combination of the two. The size of the payment depends largely on the stage of product development that you're in. To the extent that you're farther along in the product development, which would indicate that commercialization is more likely than if you're in an early stage of product development, the upfront payment will fluctuate based on that. Universities, like we just said, I don't know, maybe these questioners saw my slides ahead of time, but universities, like we just said, are often interested in equity. Companies do that as well, but there is a trend, and there has been a trend for years. The amounts are increasing for sure. So think about those percentages. Those are the percentages that you're seeing on the slide are significantly higher than they have been in years past. And that's becoming a huge trend among the university community when it comes to university licenses. You're going to see milestone payments. Certainly you're going to see royalties. Royalties are typically paid on net sales of licensed products. And there's lots of different ways to structure royalties, but you will likely see a royalty-based licensing position in the economic section or the financial section of a license agreement. You might see some R&D payments or some manufacturing payments, or other types of payments that might be applicable to a particular licensed product or a particular intellectual property. Clearly, I'll leave you with the thought down there in bold and italics. Make sure if you're the licensee that you know when you're supposed to make these payments. And clearly express how the payments are to be calculated, particularly when it comes to royalties. You have to go back, if royalties are based on net sales, you really have to go back to the beginning of the document and find that definition of net sales. And you have to, again, I always like to take a step back, digest it, talk to the appropriate people to make sure that that definition is tailored. Whether you're the licensor or the licensee, it really doesn't matter. Make sure that that definition is tailored to meet the business objectives of the company. Really super important. There can be lots of different types of monetary considerations, a little bit more unusual, but you could have a profit sharing scenario. How are profits calculated? These are really common in co-promotion or marketing or sales agreements. They're way more complex than royalty structures. They require really defining how profits of a particular product or a particular company are calculated. So even more critical that you look at that in these scenarios than it is that you look at net sales in other scenarios, although both are critically important. This structure just does tend to be a bit more complicated and takes a little bit more time to parse through. And then there's the concept of anti-stacking, particularly in your university licenses, but in any license agreement, you're going to want to think about what stacking means. And you're going to want to think about how do you implement if you're the licensee, an anti-stacking protocol in your license agreement. If the licensee makes a determination that it's necessary to pay to a third party some royalties associated with the licensing of intellectual property that's necessary to develop or commercialize a product, the licensed product, then you're going to wind up as the licensee having to pay royalties to lots of different licensors in order to get the commercial product to market. At some point, the royalty structure and the payment structure is going to make less and less commercial and financial sense to the licensee. And so we impose what's called an anti-stacking protocol, where to the extent that we, the licensee, have to make payments to a third party to license their intellectual property in order to ultimately commercialize a licensed product, we can deduct whatever amount we have to pay that other licensor from the royalty payments otherwise owed to the initial licensor up to a certain percentage. And that percentage is typically up to 50%. We've seen varying degrees of that, and there's lots of different ways to slice this up. But when you hear the concept of anti-stacking, that's what we're getting at. And it's really critical to understand what that means as the licensee, and understand that we need to implement processes and standards and contractual language that supports our business objectives and makes it reasonable for us to go forward and commercialize a product. This is helpful in that regard, so that we can ultimately bring a product to market and again result in that win-win-win scenario, where otherwise perhaps it wouldn't make sense for us to bring the product to market. I'm going to skip ahead a little bit. Unfortunately, I see that we're running out of time. Talk a little bit about governance. Remember that these are collaborations. These are companies coming together to accomplish something. A license agreement is a collaboration. A joint development agreement is a collaboration. We are coming together in order to drive something forward, to develop a commercial product, to come up with new intellectual property, to do something. And so we want some level of governance over that. We want to monitor the life of the relationship, and we want to be in a position to anticipate issues and to solve for them as quickly as we possibly can. Because remember, as I said at the very beginning, these are long-term relationships, and we want them to stand the test of time. We don't want them to go sideways and explode. That doesn't help anybody. That's kind of a lose-lose for everybody. We want to anticipate issues, and we want to efficiently solve for them. This can be critical to the process. And so thinking about how to legislate, how to govern the relationship is important. And it can get very granular, from committees to how many people are on committees to the frequency of meetings and where meetings are held. But think long and hard about what will it take to ensure the success of the collaboration. How are issues going to get resolved? Do we have an active engagement on a development plan? Do we have active engagement on what commercialization means and what the commercialization plan is? Do we have active engagement with respect to getting our product through regulatory approvals? How do decisions ultimately get decided? Do we need unanimous consent? Do we need a consensus? Who's participating in the decision-making process? Are there time limits associated with how long we can debate these issues in order to bring them to resolution? All of that becomes critically important when we get together with other companies and try to achieve some desired result among us. Termination, something we never want to think about, but unfortunately we have to. When does it happen? And what is the impact of it happening? What are the mechanics associated with termination? And then ultimately, what are the consequences? Who walks away with what? Certainly Mike's question earlier was talking a bit about what the licensor gets associated with a termination of the agreement, and what is that reversion of rights. The licensor will reserve for itself certain rights in a license agreement, and certain rights will revert back to the licensor in certain circumstances if a license agreement is ultimately terminated. What happens to regulatory approvals if we're at that stage of the relationship, and then who's responsible for what with respect to data and improvements and developments and all of the things that might have come out of the collaboration between the parties. All things we think about. Unfortunately, of course, because we don't want to anticipate that a relationship will ultimately be terminated. But if we don't, then we'll really be in a bad position when the unfortunate reality happens that these relationships sometimes do get terminated. I talked a little bit earlier about the university license. I'll leave you with a couple thoughts about university licensing. A lot of you are involved in university licensing. Certainly we do quite a bit of it. Technology transfer offices of universities are responsible generally for moving products from lab to industry, and that's what we facilitate through a license agreement. Again, it says here, I can't say it enough, a well-executed license creates a win-win situation, incentivizing a company to create new products and allowing the university to continue its research and investing in research and sharing in the economic upside of that investment in research. These are generally, they do follow everything that we talked about today. So there'll be a license grant, and there will be all of the bells and whistles following the license grant. In terms of economics, again, you see here on this slide, a lot of the same things that we talked about earlier. License fees or upfront fees, Sometimes there's an equity investment. Often there is, as we discussed, royalties and so on and so forth. Mike, you're back. Are you telling me I have to wrap up?
Yeah, and there's one final question,
Okay,
which
let's go to that.
even I think I can answer, which
Oh.
is, do you get more money if you have a granted patent as compared to a pending patent application?
I hope you agree, Mike, that the answer is yes.
Yes. So, and what I was going to do is pivot to, which is why, we encourage folks who are seeking patent protection to consider accelerating the examination of those patent applications in order to get a granted patent in your hand that covers your product so that you can get better terms. So,
absolutely.
So with
so
that,
I'll leave you with
ahead,
one
Matt.
final thought, if I could. I've included, I think everybody gets the slides.
Yep.
I've included in the back a checklist. It's not comprehensive, so please don't take it as everything you possibly ever need, but just a checklist as you're perusing these agreements or thinking about entering into, just some things to keep in mind so you don't have to go through all the deck and whatnot. But a nice checklist. I use checklists in my practice. I know a lot of us do. And I certainly like using them. So something to leave you with that I hope is helpful for you in your endeavors. And I invite you to reach out, call, email, if you want to continue the conversation. You can probably tell I like talking about this topic, and there's certainly so much more here. And everybody at MoFo I know is more than happy to impart our wisdom on all of you and help you along the way. So please reach out. It was my pleasure being here. I thank you for the opportunity, and I'll turn it back over to you, Mike.
Thank you, Matt. And thank you all for attending. We hope you enjoyed the course. There are many other offerings that MoFo provides, and you're now on our email list. So we look forward to seeing you in the future. All right. Thanks, Matt. Have a good day, everybody.